Okay, so we were talking about probate and avoiding probate. Is there any way that you can avoid probate altogether?
Yes. What I do when a family comes to me and they'll say that mom or dad died, and would I handle the estate or take them through probate? I take a sheet of paper and I make 4 columns on it. And one column is joint assets, one column is beneficiaries, one column is trust, and the other column is sole name. And then I go through asset by asset. How is the title in that asset? The house, the house was joint with dad. Or dad died earlier, so the house was in mom's sole name. IRAs have beneficiaries. Annuities have beneficiaries. Life insurance have beneficiaries. That goes in that column. If she had a trust, then we look at the things that were in the trust. And then when I'm all done, I've got all the assets, I go over to that sole column. Wasn't joint, there wasn't a beneficiary, it wasn't in a trust. Those are the assets that have to go to probate, and only those assets.
So can you look at that one column and say, we can take care of this, so no probate, or these are the things that will go to
yes,
probate?
If they're coming in to see me before a death, then we tell them, we've got to take care of these items in the sole column and either make them joint with somebody or put a beneficiary on them or put them into a trust.
Well, let's talk a little bit now that you mentioned it,
Yep.
joint.
Okay, joint property is a way of avoiding probate. Mm-hmm. And for husbands and wives, I think it's a great way to do that. But I think it's a huge mistake on the death of mom or dad, for them to add one or more of the children on as a joint owner. And I'll just give you some examples.
Please.
Okay, let's say start with the bank account, and then we'll go to real estate.
Okay.
In a bank account, if you add one of your children to the bank account and you die, it goes to them and it avoids probate. But if you have 4 children, the one gets the money. There's no law that's going to make them share. Okay? I had a situation once where everything was taken care of except for $30,000 in an account. And my client said, well, that's going to my brother. He's going to pay the funeral bill and divide what's left. I said, I'm not comfortable with that. And he said, don't worry about it. Okay. So he died, and he took the $30,000 and he said goodbye. Didn't pay for the funeral, didn't come to the funeral, just decided that his family was worth less than $30,000. He'd rather have the money than all of his brothers and sisters, and so he took off with the $30,000. So the point is, if you name one child as a joint owner, they do not have to share with the others. Mm-hmm. If you name all 4 of them as joint owners, it creates a different problem that I'll talk about in a minute. Mm-hmm. So, but let's say also, what you intend to do when you make them a joint owner is for them to get it when you die. But that's what a beneficiary is. What the law says you actually are doing are making them a co-owner. So they now co-own that account with you. You've made a gift to them. It's not taxable, but you've made a gift to them. And if unintentionally, let's assume you've got the most wonderful children in the world and they would never cheat you, but unintentionally, if they get a divorce, that's part of their marital property. If they file for bankruptcy, the bankruptcy court's going to come and take money out of your account. If they get sued and they get a judgment against them, the judgment creditor is going to take money out of your account because you've made them a co-owner, and so they own part of that account. So whether intentionally or unintentionally, it's not a good idea to make your children joint on an account. It's much better to make them a beneficiary. Real estate is slightly different. If you want to sell real estate, all of the owners have to sign the deed. So if you add 1 or more children to the property and then you want to sell the property, they have to sign off on the deed. And I had a case where dad died, and so mom, after 3 or 4 years, decided to get married again. And the plan with the new husband was that she would sell her house and take the cash and move in with her new husband. Well, she had added her children to the deed. And the children said, we're not signing that deed. And it wasn't my case, so I can't tell you what their reasoning was. It may be that they didn't want mom to marry that guy, or it may be they didn't want mom to take the cash and put it in a joint account with the new guy, and then they weren't ever going to get the money.
Right.
I had another case in Livonia in 1987. Lady's husband died, and so she went to an attorney, and he drew up a deed and made it joint with her daughter, which I think is a mistake. Mm-hmm. 25 years later, mom is in her late 80s, and now she can't keep it up anymore, and she wants to move to assisted living, and she doesn't have any money except she's got $200,000 equity in this house. So $200,000 would last her a long time in assisted living. So she goes to the daughter and says, we need to sell the house. We need to do a listing. You have to sign the listing. Then you have to sign the deed. That's what the broker told me. And her daughter looked her right in the eye and said, I'm not signing anything because you'll just sell the house and spend the money. And if I don't sign, then you'll die and I'll get the house.